be seated. Good morning. We're on the record in case number 12 CF 1083A, State of Florida versus George Zimmerman. We had a couple of housekeeping matters and motions that we needed to take care of first. We have the defendant's third motion to continue. Are you ready to proceed?
Mr. Zimmerman's on his way in.
Oh,
Can we?
sure.
Yeah, there's just working through some of the particulars of getting everyone in the courtroom on time.
Okay, the record will reflect the presence of Mr. Zimmerman. Are we ready to proceed on your motion?
Yes, Your Honor. The motion, I believe, speaks for itself in that it outlines a number of items that have come up to our attention only very recently, including, I don't want to just restate what I know that you have read, but a particular note is a report that we received on June 4th. I believe that it is similar to a previous report. The problem with it is until you compare 3.5 gigabytes to 2.5 and 1,000 pages to 1,000 pages or thereabouts, it's hard to know the differential. And as importantly, as you know, this has been an ongoing concern with the court regarding data from Mr. Trayvon Martin's phone. Uniquely, it's not like handing over a book because, as the state suggested through their examination, once they give you the bin file, they may believe that that accomplishes it. It doesn't, in our opinion at least. And we certainly have some reports that we were now known were identified by one of the witnesses who testified before you, I think, on Thursday. That evidenced reports that we know were generated and available to the state that they have not forwarded. So that's one particular issue that we simply have hours, it could be tens, it could be hundreds of hours to still accomplish within the context of making sure that we both have all the information resident on the phone and have had the opportunity to then do whatever additional discovery is required because of that. That's one issue. You know from the testimony over the weekend that even Mr. Reich, one of the experts, has testified that he still has, I think he said 100 hours, or certainly a lot of work to do before he's even completed with his report. While that is somewhat contingent upon the underlying decision that you might make in the Fry decision, were you to make the decision that is, in fact, admissible testimony, then that would require potentially a lot of more work to both wait for Dr. Wright's report, evaluate it, get an expert to counter it. We may have some, but we may need more. It's just hard to say until we know. We do have Mr. Crump's deposition. That is certainly accomplishable. It's probably not more than a several-hour event once we get it scheduled. But the preparation and doing it, and as importantly, I think more importantly than the actual words of Mr. Crump's deposition, is going to be that which we uncover from that deposition and what needs to be done to accomplish further discovery in that regard. So in sum, you've heard me say this many times before. We have been working very diligently in the past 16 months to get this case ready for trial. We've tried very hard. The hours spent on this case by the defense, I'm sure, approach what the state has spent on it, and it has been in the easy thousands of hours, but we're not fully ready. And we have issues that I don't want to come up in a trial that we were not otherwise prepared for because of time. So, though I know we have an enormous amount of resources accomplished to do this today, we're not fully ready and we need more time. That time may be as short as a few weeks. It may be as short as a couple of weeks. The problem is we don't know until we actually do all the work that we need to do. And even with the efforts done to date, we need more time.
Thank you. State.
Your Honor, with all due respect, we would object to any continuance, and we dispute the facts as cited in their motion. Just for two instances, two things that Mr. O'Mara mentioned today, this morning. Mr. Crump's deposition, the 5th DCA has severely limited what they can ask. That shouldn't take more than, quite frankly, half an hour, but even if it took 2 hours, it's doable. We have plenty of time. As the Court is well aware, we worked last Saturday. I'm not suggesting we got to work next Saturday, but we have plenty of time, and they've got a slew of attorneys. I mean, we can, anyway, so that shouldn't be a problem. Number two, regarding the bin file or the victim's cell phone information, we respectfully contend that that was turned over in February, a complete thing. They have their own expert that has reviewed it. Their own expert even found stuff that we had not found. The latest report was Mr. Breton. I asked him to go ahead and do another report. And every time you do a report, you get more potential things. They have the ability to do their own report. They've got an expert. So that is not a grounds, with all due respect, to continue this case, because they have the ability to do everything that we have been able to do. And, in fact, they've done more as to victim phone records. And on top of all that, most of that stuff, if not all of it, is irrelevant, and the Court has already made rulings to that effect. So we respectfully ask the Court to deny their motion for continuance.
Okay, thank you. Any further argument?
Just briefly, the Court did not determine that that information was irrelevant. What she said was that we should be circumspect and that we would not be able to, nor would the State be able to address those issues in opening, wholly appropriate, and actually what we had asked for as well. Other than that, it's just really a question of whether or not we truly can be ready.
Okay, thank you very much. The motion, third motion for continuance is denied. There's the State's motion to compel discovery regarding defendant's expert reports. Is that resolved?
We've not resolved that at our Saturday hearing.
Okay, thank you. And then there's the defendant's motion in limine regarding use of certain inflammatory words. I asked counsel if they could meet and see if there was any agreement. If there wasn't, I would rather have that after we do the jury selection before opening.
Then I would ask at least that we be admonished not to use such words in jury selection.
That should be agreed upon.
I don't have any objection to not mentioning those specific words in jury selection.
Okay, thank you. Are there any other motions that are out there pending that the Court has not brought up this morning?
I had asked you to revisit the sanctions motion because I had mentioned to you that I had some alternatives to simply not handling that matter until after the trial. So I'll state it, and the State would probably need an opportunity to respond. It may not be appropriate for right now, but I think it needs to be addressed before jury selection. So if I might.
Briefly.
Sure. Our motion for sanctions is based upon the failure to give information, and you haven't fully ruled on that. But to the extent that we have, in fact, been prejudiced or delayed in the preparation of that evidence based upon the late notice or failure to give by the State, I'm asking that the Court consider relaxing authentication rules or other evidentiary rules that, had we gotten the information when we were supposed to be given it in February or shortly thereafter, we would have had the information, had the opportunity to build up the evidence and discovery necessary for authentication purposes. So, though it may be on a one event at a time process, we don't know yet, but if in fact some of that evidence does become relevant and it's otherwise admissible, and then we do not have the proper authentication that I could prove to you we otherwise would have had with efforts
Okay.
made.
We'll take that up on a instance-by-instance basis.
Sure.
Okay. And just so everybody knows the process and the procedure that we're going to be doing to start the jury selection, first of all, counsel will make their appearances for the record.
Bernie Delvion on behalf of the state of Florida.
John Guy on behalf of the state of Florida.
Rich Mancutt, bring on behalf of the people of the state of Florida.
Mark Romero on behalf of George Zimmerman.
Your Honor, Don West on behalf of George Zimmerman. Also seated at council table is Mr. Robert Hirschhorn.
Good morning, Your Honor.
Good morning. And have Mr. Zimmerman in the
Lauren
back.
Stewart on behalf of Mr. Zimmerman.
Do you want to make your appearances? You're sitting at the table.
They are unfortunately not quite lawyers yet, Your Honor. So while they're here with the court's allowance, they're not members of the bar.
Okay, thank you very much. The procedure that we're doing is Judge McIntosh is downstairs qualifying the entire venire. There are other cases that are set for trial this morning. As soon as she has finished, the attorneys and I will be going down there. We're separating out 100 prospective jurors. We're going to go down there and I will give them a juror questionnaire that they will complete. Once that questionnaire is completed, the clerk's office will gather them and will make copies for counsel in the court. We will review those and send jurors up one at a time for individual voir dire. Once we have 21 of those people, we will start our regular jury selection process. So, Sarah, do we know if Judge McIntosh has finished? Do you waive Mr. Zimmerman's appearance of going downstairs to present the jury questionnaire?
I think I'd rather have him present, Your Honor. Thank you.
Okay.
About 20 more minutes.
20 more minutes? Okay. Is there anything that we could take up in the period of time that we're waiting for the venire to be qualified?
I would just request, I know that we modified, or the court modified the questionnaire. If we could have the final version, I think both sides, I know we met and the court was going to modify it.
I don't have copies. If you want to come up here and share and look at this one.
And one other thing we had is, I know the state has tendered to defense counsel potential witnesses, and I think it's 240-something. We were waiting to hear back from the defense as to whether we could cut down some of those people or not, and I think we're waiting still from the defense.
We have cut it down significantly. I was going to suggest that Mr. Guy and I get together, since we've sort of taken the lead when the questionnaires come up, and I'll go over with you. It's quite severely limited, I think, with some concepts I want to talk to you about.
Well, I was going to, you will have time to do that because I was going to give that list to the 21 who would be seated for the regular voir dire. If you wanted to come up and...
Yes. And, a chance we can actually accomplish a copy of it while we have a few minutes?
Well, I'll have you look at it and then we can get you a copy of it.
Thank you. Oh, I apologize. To Your Honor, and we appreciate the court allowing us to review it before it's tendered to the jury.
Okay, thank you. And while that you're up here, I wanted to put on the record, we had discussed the procedures for jury selection. Are there any objections to the procedures? Mainly, the defense have requested that we go down and speak to the potential 100 jurors about the questionnaire and introduce everybody. Is that correct?
It is, Your Honor.
And there was no
We
objection
have
from
no
the
objection,
state?
Your Honor.
So the procedures that the court has stated have been accepted and by both sides. Is that correct?
That is correct, Your Honor.
We, of course, as you recall, had outlined an objection to not using the full questionnaire that we had suggested. You had ruled on that. I just want to renew that for whatever purposes necessary.
Okay. Based upon my ruling and my preparation of the questionnaire, there are no other objections to the procedure?
That's correct, Your Honor.
Okay, thank you. We'll make copies. juncture, what I'm prepared to do is, while we're waiting for the jury qualification to be completed, is to go back into chambers. I'll have copies of the confidential juror questionnaire for counsel, not to be distributed. And as soon as we know that we're ready, counsel and Mr. Zimmerman will come back and we will go downstairs. Court is in recess at this time.